it's time once again for Let's Talk Legal. Compliments of Neumann van Rooyen attorneys. And this week we've got Tumi Mokobe. And today we're going to be chatting about the legality of municipalities cutting off consumers' electricity. Tumi, as always, thank you for joining me in studio.
Good morning. Thank you very much for having me here, and it's a pleasure.
Now, first of all, is the municipality allowed to cut off a property's electricity when water and electricity is owed?
Yes, most definitely. Our law currently makes provision for such, and the municipality currently do have a right to cut off a consumer's electricity should he or she be in arrears.
And what is the procedure before such steps could be taken by the municipality?
First of all, it needs to be ascertained the reasons for the cutting off of the municipality. If it's a matter of a certain account being in arrears, then the municipality is legally obligated to give a notice to the person responsible for the account. A minimum of 14 days written notice of termination is required for water and electricity accounts in arrears. And if the notice is shorter than 14 days or so, then meaning the disconnection thereof shall be deemed illegal. However, the 14-day notice gives the responsible party an opportunity to present any disputes or queries they may have regarding the account or allow them to repay the arrears. So basically that period just allows you to inquire from the municipality or maybe make a payment or maybe some sort of a payment arrangement and so forth.
All right, so now what steps can be taken should the municipality not abide by the 14-day rule?
We all know we always have the courts at our disposal in that regard. However, the procedure thereof shall be the consumer may consult his or her legal practitioner in that regard in order to get some legal advice. But before you can do that, if you don't have the means or the funds thereof, you can always approach the municipal offices in order to ascertain what the reason of the disconnection is. And then should it be ascertained that it's basically based on arrears and so forth, but you didn't get that notice, then your legal practitioner will bring forth a spoliation application. This is an urgent application towards the court to indicate that the municipality has actually disconnected my electricity illegally, and this is a matter of urgency because it's one of the requirements that you actually need to meet in order for this application to be granted. But however, it needs to be mentioned that, remember, the 14-day rule is not applicable should the municipality ascertain that you have actually tampered with the meter readings. The municipality may then, with immediate effect in that regard, and disconnect your electricity or water without prior notice, and also lay criminal charges against you as the owner of the property or the occupant thereof.
But now, what if you have a problem with your account and the municipality wants to disconnect?
Once a query relating to the account has been put in, the municipality may not disconnect the services. But also there is an element that needs to be met in this regard. It's actually applicable with when the amount in dispute, meaning the amount that you're actually querying, is equal to the amount in arrears. In the case where the amount is less than the amount in arrears, the service may be disconnected for the undisputed amount. If I make you a practical example, for instance, you have a query about your 60,000 towards your account of 100,000, meaning there's still 40,000 which you don't dispute. So meaning the municipality still does have the right to disconnect your electricity. However, if your query is in relation to 100,000 and your bill is exactly 100,000, then the municipality first have to sort that out before they can cut off your electricity. But at the same time, on a monthly basis, while your query is still being adjudicated upon, then you have to, or there is still a duty upon you placed to pay your monthly rates and taxes and so forth towards the municipality.
So what happens if I am the owner of a property which is in arrears incurred by the previous owner thereof?
Currently, the legal position in that regard is a bit vague because I remember there's a case in 2016 which was adjudicated upon by the Rooyen local division, but it did not set any precedent in that regard because it indicated that a municipality may not terminate the purchases, electricity or water supply as a result of outstanding debts incurred by the prior owner of the property. So meaning this principle is yet to be tested in a court of law. So there is no conclusive answer to that as it stands. It's just a matter of the specific judge or the specific court which you might approach in that regard, and which precedent they will decide to follow.
All right, now do you have any last words of advice?
When it comes to things of electricity disconnections by the municipality, it is very, very important for consumers or owners of property to align themselves with the law. And also, should it be that you find yourself in that position, you're always open to consult with your legal practitioner to seek advice before you take any steps, because this is very essential. There's a lot of instructions coming our way pertaining to these issues, because I think municipalities have taken it upon themselves now to cut off people's electricity whom are in areas in order to generate the income, which obviously results to the people getting services and so forth. So it's very essential to align yourself with the municipal law in that regard.
All right, so there we have it. Tumi, thank you so much for joining us in studio once again.
It's a pleasure.
So that was, of course, this week's Let's Talk Legal. Compliments of Neumann van Rooyen attorneys. Remember, if you want more information, head on over to their website at www.nvrlaw.co.za.